Good evening, everyone. I welcome on behalf of Advocate on Record Aspirants Academy to the 7th lecture series. Today we have gathered here to discuss about the origin of public interest litigation. Before going into the topic for today, it is our everyday prayer that we recite the preamble to remember our forefathers, and we try to do our best to bring their dream come true. So let me request each one of you to recite the preamble along with me. Therefore, we will remember our duties. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you. So today we are going to discuss about the origin of public interest litigation. This is not only will be helpful for our practice, but also for advocate on record examination. Now, if we see where to start the PIL, we need to start from the Article 32 of the Constitution of India, because there is no specific provision to file public interest litigation. You can file public interest litigation only by invoking Article 32, and it depends upon the prayer whether it is individual's violation of fundamental rights or the case concerning the interest of the public at large. So therefore, let us see first Article 32 Clause 1 of the Constitution of India. Article 32 Clause 1 provides the right to move the Honorable Supreme Court by way of appropriate proceedings for the enforcement of the rights conferred by this part. This part means that is part 3 of the Constitution of India, right? So now the right has been given to us, the remedial measure for the violation of the fundamental rights guaranteed under part 3. So whatever the fundamental rights that are guaranteed, be it right to equality, right to freedom of speech and expression, or any other rights, right to life or personal liberty, right to freedom of religion, right against untouchability, right to education guaranteed under Article 21A of the Constitution of India. So whenever there are violations of these fundamental rights, we can approach the Honorable Supreme Court under Article 32 Clause 1. So once we file a writ petition before the Honorable Supreme Court, the first question that comes to the petitioner: what is your locus standi? How do you maintain the writ petition? If the other side raises a question, the preliminary objections with respect to the maintainability of the writ petition, we are bound to answer to the Honorable Supreme Court. So you must understand what is locus standi means. It derives from the Latin word. Locus means place. Locus standi means the place where you stand. So how are you going to maintain this writ petition before the Honorable Supreme Court? We need to establish two ingredients to maintain a writ petition. Firstly, that there is a fundamental right guaranteed to you, guaranteed to the petitioner. So now you have established, yes, there is a fundamental right guaranteed to you. Number two, how you are aggrieved by violation of such fundamental rights. So you must establish that there is a fundamental right or a legal right and you have suffered with a legal injury. When these ingredients or these elements are established before the Honorable Supreme Court, that means you have established your locus standi and justifying the maintainability of your writ petition. But there were several questions asked before the Honorable Supreme Court on various occasions. What was that? Whether the Honorable Supreme Court is meant only for the corporate people, or is it meant only for the rich people who can access to the justice? Does it not, whether the doors of the Honorable Supreme Court is not open to the litigant who hails from far south, down south, or is it not accessible to the poor, underprivileged, economically, socially, politically backward? So those questions were asked by the Honorable Supreme Court themselves on several occasions. The answer, where do you find? The answer you will find in the preamble of the Constitution of India itself. The preamble of the Constitution states like this: we the people of India, that means it includes all the people in India, and to secure all its citizens. It is not something it is securing only to rich people, corporate people, who is born with a silver spoon. No, to all its citizens. What? Justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Therefore, collectively, if we read the entire preamble, it is not for selected people. It is for all the citizens of this country. So therefore, the next question that comes to the minds of the honorable judges were that if these rights are provided to all the citizens, but does it truly followed? Whether the fundamental rights guaranteed to the citizens of this country, whether they can have access to the justice. If a person who are languishing in jail, who will argue on their behalf? A person, children, when they were exploited, who will come to the court to get justice? Underprivileged, bonded laborers, those who come from the very poor background and they are not even informed, they are illiterate, they are not aware about their fundamental rights. What is Constitution of India, they are not aware. Then how will they approach this honorable court? So therefore, though our forefathers guaranteed the fundamental rights to everyone, but in true sense, those people were not able to have access to the courts. So therefore, the Honorable Supreme Court were questioning themselves how to entertain the writ petitions filed by the underprivileged people. How do you make the Honorable Supreme Court doors open to the poor, underprivileged or economically, socially backward? So they were waiting for the occasion to invoke their powers. The Honorable Supreme Court's power is supreme and it is being the highest court of the land. Under Article 142 of the Constitution of India, they can pass any orders to do complete justice. Therefore, dear friends, the origin of PIL by diluting the doctrine of locus standi. So what is the hindrance that the Honorable Supreme Court was facing is because of the narrow interpretation given by the previous judgments, that if you want to maintain a writ petition, you can maintain a writ petition under establishing two essential elements, that is, you have a fundamental right and you are suffered because of the violation, therefore aggrieved person can alone maintain a writ petition. So that locus standi is preventing the other poor people to approach the Honorable Supreme Court. Now the answer is, now we have found and diagnosed the problem. The problem is locus standi, and how to dilute it. If you dilute the doctrine of locus standi, the doors of the Honorable Supreme Court will be open for everyone. So therefore, the Honorable Supreme Court liberalized, diluted the doctrine of locus standi, meaning thereby a underprivileged, a bonded laborers, a person those who are languishing in jail for many years, women, transgender, whoever are affected, and if they are not in a position to have access to the justice at large, then what happens? Any public spirited person, any person who is well informed, who can engage a lawyer, they can file, a public spirited person can file a writ petition in the interest of public at large. Therefore, he need not establish that there is a locus standi. He can establish that there is a fundamental right guaranteed under Part 3 to the citizens of this country. They are underprivileged, they are very poor, they cannot have access to the justice. Therefore, I am filing this petition on their behalf. So the Honorable Supreme Court has diluted the doctrine of locus standi and encouraged the public spirited person to maintain writ petition on behalf of voiceless people. Right? So let us discuss about in what are the circumstances, on what occasions the Honorable Supreme Court had the privilege to evolve the public interest litigation by diluting the doctrine of locus standi. This public interest litigation has originally originated from the United States of America, where in the United States of America, where the persons, those who are languishing in jail, they were unable to approach the highest court of the land. So therefore, the United States of America courts, they have come out by saying that there must be a lawyer, there must be a legal aid, providing legal aid to the prisoners, and legal aid councils can represent on behalf of the prisoners. Therefore, they can fight on behalf of the voiceless people. So that is how PIL was originated in the United States of America. Now, our honorable judges was apprised with the latest developments, what is happening in the developed countries, and they had a question, why don't we apply to our India? So on the first time, for the first time, the Honorable Supreme Court had the occasion to deal with doctrine of locus standi. Let me refer that case law to you, dear friends. In the year 1976, let me tell you the cause title first and the citation. The citation is 1976. This is where the beginning of the evolution of PIL. 1976, volume 3 Supreme Court cases, page number 832. I repeat, 1976, volume 3 Supreme Court cases, page number 832, comprising of Honorable 2 judges, Honorable Justice V.R. Krishnaiyer and Honorable Justice N.L. Untwalia. N.L. Untwalia. So the name of the case is the Mumbai Kamgar Sabha. The Mumbai Kamgar Sabha, Bombay, versus Messrs. Abdul Boy, Faizullah Boy and others. Abdul Boy, Faizullah Boy and others. Dear friends, this judgment was decided on 10th of March 1976. 10th of March 1976. This is arising out of the labor disputes. Let me give a brief background. This was arising out of the labor disputes where the laborers seeking customary bonus that was deprived by the employer. So matter was referred to industrial disputes. Award was passed, which is not in favor of our workmen. So instead of workmen approaching the Honorable Supreme Court, it was the union who is representing the workers. They approached the Honorable Supreme Court. Now the preliminary question objection was raised by the respondent was, this union was never a party before the industrial dispute tribunal. So therefore they are not aggrieved. It is a dispute only between the workmen and the employer. Therefore union cannot maintain a petition at all. So therefore they do not have locus standi to maintain this petition. So that was the objection raised. But the Honorable Supreme Court had the occasion to discuss about how the rich people, how the millionaires having access to justice, but poor laborers, they are not able to have access because they are poor, they are underprivileged, they cannot afford the lawyer's fees. So therefore the locus standi was diluted to some extent, and the Honorable Supreme Court has held that union is nothing but representative of the workmen, therefore they can maintain a writ petition. So I would like to read few paragraphs from this judgment, therefore that will give you more clarity. So this is under Article 136, Practice and Procedure, Labor Dispute. Labor union will be allowed to contest on behalf of the workmen. Technical law will not be allowed to defeat the cause they seek to justify. Broader conception of locus standi and liberal approach to procedural technicalities called for. So what was the preliminary objection? Preliminary objection was taken on behalf of the respondent employers that the union could not be the appellant since the dispute was between the workers and the establishments. But preliminary objections cannot stand since in substance the union represents the workers. The objection is purely technical and is not justified on facts. Now let me take you to the relevant portion where this doctrine of locus standi is discussed. Very, very important. It is discussed in paragraph number 7 of the judgment. Dear friends, you must appreciate the concept of PIL, how it got evolved. This was the first judgment. In paragraph number 7, they were discussing. Let me read. Fairness to respondents' counsel constrain us to consider in limine a flawsome plea forcibly urged that the union figured as the appellant before us. Union figured appellant before us, but being no party to the dispute, which was between the workers on one hand and the establishments on the other, had no locus standi. No right of the union, qua union was involved, and the real disputants were the workers. Surely, there is no terminological lapse in the cause title because, in fact, the aggrieved appellants or the workers collectively, not the union. When a union has filed this petition, if you see who are all there in the union, it is nothing but the workmen. So therefore, it is only a technicality plea that you are raising objection against the maintainability of the petition. Otherwise, it is a petition maintained by the workmen only. But a bare reading of the petition, the description of the parties, the grounds urged, and the grievances aired leave us in no doubt that the battle is between the workers and the employers, and the union represents as a collective noun, as it were the numerous humans whose presence is indubitable in the contest, though formally invisible on the party array. The substance of the matter is obvious, and formal defects in such circumstances fade away. We are not dealing with a civil litigation governed by the Civil Procedure Code, but with an industrial dispute where the process of conflict resolution is only informal, rough and ready, and invites a liberal approach. Procedural prescriptions are handmaids, not mistresses of justice, and failure of fair play is the spirit in which courts must view processual deviances. And so and so, and I am coming to the very important paragraph now, where foul play is absent and fairness is not faltered. Latitude is a grace of processual justice. Test litigations, representative latitude is a grace of processual justice. Test litigations, representative actions, pro bono publico, and like broadened forms of legal proceedings, are keeping in view with the current accent on justice to the common man, and a necessary disincentive to those who wish to bypass the real issues on the merit by suspect reliance on peripheral procedural shortcomings. Even Article 226, viewed in wider perspective, may be amenable to ventilation of collective or common grievances as distinguished from assertion of individual rights. Although the traditional view, now the honorable judges, the honorable Supreme Court is discussing that the traditional view was the narrow interpretation given to doctrine of locus standi. So maybe even Article 226, viewed in wider perspective, may be amenable to ventilation of collective or common grievances as distinguished from assertion of individual rights, although the traditional view, backed by precedents, has opted for the narrower alternative. Now, the first time the word is used, public interest. Public interest is promoted by a spacious construction of locus standi in our socio-economic circumstances. See, the preamble of the Constitution says justice, social, economic and political. That what is enshrined in the preamble is being brought in the judgment. See, it requires a spacious construction. Locus standi should not be narrowly interpreted. It requires a spacious construction of locus standi in our socio-economic circumstances, and conceptual latitudinarianism permits taking liberties with individualization of the right to invoke the higher courts where the remedy is shared by a considerable number, particularly when they are weaker. When they are weaker section, definitely a public interest or the interpretation of the locus standi is to be widened. Less litigation consistent with fair process is the aim of adjectival law. Therefore, the decisions cited before us, founded on the jurisdiction under Article 226, are inept and themselves out of tune with the modern requirements of jurisprudence called to benefit the community. So, dear friends, from this judgment 1976, What did the Honorable Supreme Court has held is, when the union is trying to maintain 136 petition, that is special leave petition, the preliminary objection was raised was that it is the union who is preferring an appeal before this Honorable Supreme Court, but the real dispute is only between the workmen and the establishment. Therefore, where is the question for the union to maintain special leave petition? So it cannot be maintainable. Even on the maintainability itself, this SLP has to be dismissed. So this was the objection taken by the respondents. But the Honorable Supreme Court has held, whatever you are saying, it is only a technicality. If you look at the cause title, union is there. But who is there in the union? Comprising of the workmen. If we say India, that means India means comprising of Indians. Who are all the Indians? We are all the Indians. We are part of this country. So union means it is all comprising of the workers. Therefore, don't take technicality plea, because substantial justice must be done. So therefore, the previous traditional view was locus standi, narrow interpretation was given, but time has come now to give a spacious construction to locus standi and interpret in a broader way. Therefore, access to justice, the door is opened for socio-economically backward people also. Therefore, the Supreme Court is open for everyone. That is what the preamble says. Secure all its citizens justice, social, economic and political. So this was the first case in the history of Indian judiciary is concerned. The Honorable Supreme Court had sown a seed, a PAL seed in the Indian judiciary soil. Now moving on to the next judgment, where it has evolved further. The second judgment which I want to draw your attention is Hussainara Khatoon case. Dear friends, if you find, I have referred Hussainara Khatoon case. I have put flags at 3 different places. There are several Hussainara Khatoon case. 1, 2, 3, 4, it goes on like this. The Honorable Supreme Court has passed directions, guidelines from time to time. It goes up to 1995. The starting was in the year 1979, and we have found a judgment, Hussainara Khatoon, in the year 1995 also. So therefore, I would like to draw your attention where the concept of PAL was discussed. Because our focus on this PAL, how it was discussed, how the seed was sown and it is grown up now. Let me give a brief background with respect to Hussainara Khatoon case. What is it about? There are several prisoners were languishing in jail, not after conviction, dear friends. Generally, after conviction, the convict will spend their sentence in jail. But here, no trial was commenced. These prisoners were pre-trial prisoners. Trial is yet to commence. They were in jail. And they were in jail for such many years, where if the honorable court finds to a conclusion that they were convicted, the maximum sentence was undergone by those under trial prisoners. What is the criminal jurisprudence tells us? Presumption of innocence is always there with the accused, unless and until the prosecution proves its case beyond reasonable doubt. But in the case of pre-trial prisoners, how they were languishing in jail even before the commencement of the trial, and why they were spending in jail for so many years, where sometimes it exceeds the maximum sentence or exceeds the half of the maximum sentence. Is it not causing cruelty to them? So therefore, petition was filed before the Honorable Supreme Court. and Article 32 was treated as a writ of habeas corpus, because every prisoners in the jail, they were not in a position to reach the Supreme Court. So what happened in this judgment, landmark judgment, the Honorable Supreme Court issued guidelines from time to time. But what is most important is, when this judgment was decided, there was already Maneka Gandhi was decided. In Maneka Gandhi case, the Article 21 says no person shall be deprived of his life or personal liberty except according to the procedure established by law. In Maneka Gandhi case, the Honorable Supreme Court has held it is not mere procedure established by law. The procedure what you have established must be fair, reasonable. So whether fairness is there in this Hussainara Khatoon's case? The answer is no. So therefore, the Honorable Supreme Court has held right to speedy trial, though there is no express provisions under Part 3, but right to speedy trial is implicit in Article 21. Look at the beauty of Honorable Supreme Court judgment, how it is being evolved. When we have a big heart, we can do justice. That is why Dr. B.R. Ambedkar has said that we have drafted the best constitution, but it may turn out to be worst when it is governed by the worst people. But bad constitution may turn out to be good if it is governed by the good people. Now please be rest assured, dear friends, this constitution is entrusted with the Honorable Supreme Court. Honorable Supreme Court is the custodian of the constitution, protector of the fundamental rights. They have protected the fundamental rights of every persons, every citizens of this country by their own interpretation, by their wisdom, by their experience, by their interpretation, by knowing the evolution of law across the countries. They have made sure that citizens of this country really enjoying in true sense what is enshrined in the preamble. This is the classic example. So the Honorable Supreme Court has held right to speedy trial is implicit in Article 21. Right to fair procedure is also implicit in Article 21. Right to speedy trial, that is implicit in Article 21. So therefore, dear friends, let me take you to certain paragraphs with respect to the Hussainara Khatoon is concerned. Dear friends, this is Hussainara Khatoon and others versus Home Secretary, State of Bihar. This is 1979, Volume 3 SCR, Supreme Court Reports, 1979, Volume 3 Supreme Court Reports, page number 169. What does it say? This has come up before the Honorable 3 judges, Honorable Justice P.N. Bhagwati, Justice R.S. Pathak, and A.D. Koshal. Honorable Justice A.D. Koshal. These were the honorable judges were deciding this case. Administration of justice, pre-trial detention, right of under trial prisoner to have a speedy trial, Article 21 of Constitution of India. In their petition for the issue of a writ of habeas corpus, the petitioner stated that there may be a case filed on behalf of Hussainara Khatoon has filed with others, but what is their prayer, dear friends? Please look at the prayer. In the writ of habeas corpus, the petitioner stated that large number of men and women, that means it is not only a habeas corpus seeking their release, but also seeking release of other men and women therefore public interest litigation. So large number of men and women, including children, were in jails for years, awaiting trial in courts of law, and that the offences, even if proved, would not warrant punishment for more than a few months. Although sufficient opportunity was given, the state did not appear before the court. Which state? State of Bihar. Now, the important aspects were discussed. Sorry? I will tell you. Now, let me sum up after reading this. Number one, a procedure which keeps large number of people behind bars without trial for long cannot possibly be regarded as reasonable, just or fair. You cannot keep the pre-trial prisoners inside the jail for so many years. So that is not a proper procedure. So it cannot be a proper procedure, that is, it cannot be reasonable, just or fair, as to be in conformity with the requirement of Article 21. It is necessary, therefore, that the law as enacted by the legislature and as administered by the courts must radically change its approach to pre-trial detention and ensure reasonable, fair and just procedure which has a creative connotation after the decision of the Supreme Court in Maneka Gandhi's case. Speedy trial. Now, speedy trial is of the essence of criminal justice, and therefore delay in trial by itself constitutes denial of justice. There should be a speedy trial. So if that is denied, that means that would amount to denial of justice. Though speedy trial is not specifically enumerated as a fundamental right, it is implicit in the broad sweep and content of Article 21. Dear friends, I am pausing here for a moment. Though there is no specific right, fundamental right guaranteed to us with respect to speedy trial, but by interpretation, by the wisdom of the Honorable Supreme Court, they have said right to speedy trial is implicit in Article 21. This is what we say. Though the Constitution of India was adopted on 26th November 1949 and came into force on 26th January 1950, but this case was decided in the year 1979. See the evolution, how the Constitution provisions remain same, subject to certain amendments, but how it is being interpreted, how the word is evolved. Article 21 is evolved in different forms. It has taken different avatars to provide fundamental rights guaranteed to the citizens of this country. So now, beautifully, this right to speedy trial is implicit in Article 21, and it would be entitled to enforce such fundamental right and secure his release. Any procedure prescribed by law for depriving a person of his liberty cannot be reasonable, fair or just unless the procedure ensures a speedy trial for determination of the guilt of such person. So thereafter they discuss about the bail system. Bail has to be granted by the magistrate, and they should not insist on the bonds when they are not in a position. Therefore, even the state must provide a legal aid lawyer, because prisoners, those who are languishing in jail, they are not being represented by the proper advocates. Even if they are being represented also, the magistrate pauses to furnish bonds, securities, sureties. They are not in a position. Therefore, they were languishing in jail. Therefore, the Honorable Supreme Court has held that if there is no representation, the state must provide legal aid counsel to represent them effectively. And they further said these prisoners cannot have objection to that, because they are not being represented. So they have to be represented by the legal aid counsel and don't insist on bonds and sureties when they are not in a position to do that. So the entire criminal jurisprudence with respect to the presumption of innocence was discussed. Now let me come to yet another judgment of Hussainara Khatoon, where they have specifically dealt with a writ petition. The ratio is right to speedy trial. That I will discuss, I will tell. Now, Hussainara Khatoon and others versus Home Secretary, State of Bihar, Patna. This was a decision, this was the order passed on 9th of March 1979. It is reported at page 532. 1979, volume 3 Supreme Court reports, page number 532. Yes. So what was brought to the, dear friends, please keenly observe, what was the problem brought before the Honorable Supreme Court and how that problem is dealt by the Honorable Supreme Court. So now the problem is being brought by the advocate saying that there are certain problems. What is that problem? Put forth before the Honorable Supreme Court. We find, the Honorable Supreme Court says, we find from the list of under trial prisoners filed before us on behalf of the state of Bihar that the under trial prisoners whose names are set out in the chart filed by Mrs. Hingorani today have been in jail for periods longer than the maximum term for which they could have been sentenced if convicted. Very sorry state of affairs. This discloses a shocking state of affairs and betrays complete lack of concern for human values. It exposes the carelessness of our legal and judicial system, which can remain unmoved by such enormous misery and suffering resulting from totally unjustified deprivation of personal liberty. It is indeed difficult for us to understand how the state government could possibly remain oblivious to the continued incarceration of these under trial prisoners for years without even the trial having commenced. So the judiciary in the state of Bihar also cannot escape its share of blame because it could not have been unaware of the fact that thousands of under trial prisoners are languishing in jail awaiting trial which never seems to commence. We fail to see how the continued detention of those under trial prisoners mentioned in the list of Mrs. Hingorani can be justified when we find that they have already been jailed for a period longer than what they would have been sentenced to suffer if convicted. So they have in fact some jail term to their credit. We therefore direct that these under trial prisoners whose names and particulars are given in the list filed by Mrs. Hingorani should be released forthwith in continuance of their detention is clearly illegal and violation of their fundamental right guaranteed under 21 of the Constitution. Therefore, dear friends, see the Almighty's power vested with the Lords of the Honorable Supreme Court. They have enormous power to decide the life of a prisoner. If such order is not passed, those people would continue to suffer in the prison. So when it comes up before a judge who understands the real pain and treat them as human beings, and then they passed immediate release of those prisoners when they were put in jail pre-trial, and then they went or they were undergoing sentence more than the maximum period if they would have convicted. So sorry state of affairs. Now, paragraphs is not mentioned here, ma'am, because it goes as per A, B, C, D. It is at page 536. Now, the Honorable Supreme Court in this judgment, they refer to United States of America's judgment, and finally they come to our article 39A. We may also refer to Article 39A, the fundamental constitutional directive, which reads as follows. 39A, Article 39A deals with equal justice and free legal aid. The state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall, in particular, provide free legal aid by suitable legislation or schemes or in any other way to ensure that the opportunities for securing justice are denied to any citizen by reason of economic or other disabilities. Now, in most of the districts, as well as in the state, as well as in the Supreme Court, we have got a established Supreme Court Legal Services Committee or High Court or District Court, and they have a panel of lawyers. When a person who is not in a position to have access to justice, they are not having financial means to engage a lawyer, they can approach the concerned committee, legal aid committee, and then they have the panel of lawyers. So committee will in turn refer to the panel of lawyers to file on their behalf, and the expenses borne by such lawyers are reimbursed by the committee. And it is generally said it is a free legal aid to the poor, and it should not be poor legal aid to the poor. So therefore, whenever such litigation, or we are doing it in pro bono, or when we are representing a free legal aid matter, we should do it diligently, because there the face of the Supreme Court comes into the picture, because they are the one who are providing a lawyers to the litigant. So litigant will see as a lawyer, as a representative of the Supreme Court Legal Services Committee. Therefore, extra diligence must be given by the concerned lawyer who deals with the legal aid matters. So Article 39A has given a right, equal justice and free legal right, and thereafter there are two paragraphs, dear friends. It is discussed at page 541. Please note on page 541 how the people were anguished about when the poor people are deprived of justice. So they are quoting from, it is therefore necessary that we should inject equal justice into legality, and that can be done only by a dynamic and activist scheme of legal services. We may remind the government of the famous words of Mr. Justice Brennan. So they are quoting it. Let me read that. Nothing rankles more in human heart than a brooding sense of injustice. So when injustice happens to a person, he knows the much pain. So that can never be healed at all unless and until effective remedy is given. Illness we can put up with, but injustice makes us want to pull things down. When only the rich can enjoy the law. Dear friends, how beautifully it is said. When only the rich can enjoy the law as a doubtful luxury, and the poor who need it most cannot have it. Because why they cannot have it? Because its expenses puts it beyond their reach. The threat to the continued existence of us free democracy is not imaginary but very real, because democracy very life depends upon making the machinery of justice so effective, and that every citizen shall believe in and benefit by its impartiality and fairness. So therefore, the doors of the court should not be open only to the rich people, it should be open to the poor people, because equal justice is guaranteed in our constitution. Therefore, it should be open to all. Now, and also recall what was said by Lehman about years ago in relation to affluent of America. If ever a time shall come when in the city only the rich can enjoy the law as a doubtful luxury, when the poor who need it most cannot have it, when only a golden key, will unlock the door to the courtroom, the seeds of revolution will be sown. Dear friends, see how beautifully it is said. When only a golden key will unlock the door to the courtroom, the seeds of revolution will be sown. The firebrand of revolution will be lighted and put into the hands of men, and they will almost be justified in the revolution which will follow. So therefore, considering everything, the Honorable Supreme Court has held that right to speedy trial, right to provide legal aid is also implicit in Article 21 by virtue of these judgments. Madam has asked, what is the ratio? What is the decision held in this Honorable Supreme Court in Hussainara Khatoon's case? Article 21, which guarantees right to life and personal liberty, but some of the rights by interpretation of the honorable judges, they have read into Article 21 by saying these prisoners were languishing in jail for many years, therefore right to speedy trial is implicit in Article 21. Right to free legal aid is implicit in Article 21. So this is what the law laid down in Hussainara Khatoon's case. And thanks to Maneka Gandhi case, where the procedure established by law means, they say it should be reasonable procedure, fair procedure, just procedure. So therefore, where is the question of all this test when it is applied to Hussainara Khatoon case? So therefore, the honorable judges, with their wisdom, with their experience, as a protector of the fundamental rights, they have evolved Article 21. Now let me move on to one more judgment, dear friends. That is also very, very important. That is a subsequent judgment. 1981. I will tell you. First, let me tell you where it is reported. 1981, Volume 2 SCR, Volume 2 Supreme Court Reports, page number 52. What is the name of the case? Fertilizer Corporation, Comgar Union. Fertilizer Corporation, Comgar Union, registered Sindri and others versus Union of India and others. This is a constitution bench judgment, dear friends. Honorable, this case was decided on November 13, 1980. Who are all the judges? It is a time to remember our honorable judges who delivered this wonderful judgment. Honorable Justice Y.V. Chandrachud, who is the beloved father of our present Chief Justice of India, Dr. D.Y. Chandrachud. So, Honorable Justice Y.V. Chandrachud, Chief Justice, Honorable Justice P.N. Bhagwati, Honorable Justice V.R. Krishnaiah, Honorable Justice S. Murdasa Fazal Ali, and Honorable Justice A.D. Koshal. These were all the judges, were celebrated judges, and their words still living today. The law laid down by the honorable judges is a Bible, is a Holy Quran, is a Bhagavad Gita for all of us. In this case, what was the issue first? Why this case came up before the Honorable Supreme Court? Let me tell you why it has come, what was the problem, and then how that problem was resolved by the Honorable Supreme Court. So this problem was with respect to, let me read the para number 1 where the judgment begins like this: by this petition under Article 32. So it's a writ petition filed under Article 32 before the Honorable Supreme Court. The petitioner who has approached this Honorable Supreme Court challenged, what is their challenge? What is their grievance? They challenged the legality of the sale of certain plants and equipments of the Sindri fertilizer factory. So there is a factory, the name called Sindri fertilizer factory, in which some of the plants and equipments were sold. That was challenged by way of a writ petition, whereby the highest tender submitted by respondent number 4 in the sum of rupees 4.25 crores was accepted on May 13, 1980. So it was sold and that was taken through a tender, and that tender was accepted also. Now the relief sought by the petitioners is that, what is the relief that they are seeking? That the respondent should be directed not to sell away the plant and equipment. These people are the workmen in that particular factory, and they are saying not to sell these plants to anyone. They should be asked to withdraw the decision to sell the same, and that the said decision should be quashed as illegal and unconstitutional. Reason is, these workmen, they are saying, we are working here, when they sell out the equipment, our 19(1)(g) is violated, right to carry the profession or the work, that is violated. Article 14 is violated. Therefore, it is a violation of our fundamental rights. Therefore, their decision to sell those plants and equipments must be withdrawn or quashed, and please permit not to sell them, not to permit them to sell it, which was already sold. So this was their claim before the Honorable Supreme Court. Now what was the preliminary objection taken by the Attorney General? Because it was, the other party is Union of India. So the learned Attorney General raises an issue. The learned Attorney General, who appears on behalf of Union of India, has raised a preliminary objection as to the maintainability of the writ petition. So they are saying, Attorney General raised the objection by saying how this writ petition is maintainable, on the ground that, in the first place, dear friends, very important, the petitioners have no locus standi. The petitioners have no locus standi to file the petition. And secondly, that the impugned sale does not violate any of the fundamental rights of the petitioners. So we must decide this objection before considering the contentions. So the preliminary objection is, what is the locus standi of this petitioner to maintain writ petition? And secondly, there was no violation of any of the fundamental rights. Therefore, only for the violation of fundamental rights they can file a writ petition. Here no such violation at all. Therefore, writ petition is to be dismissed. These are the 2 points urged by the Attorney General before the Honorable Supreme Court. Now the Honorable Supreme Court, discussing about the jurisdiction. The jurisdiction conferred on the Supreme Court by Article 32 is an important and integral part of the basic structure of the Constitution. Pausing here for a moment. In Keshavananda Bharati case, the doctrine of basic structure was evolved. Here, Article 32, again it is discussed, we discussed about L. Chandrakumar case also, where Article 32 and 226 was made as basic structure of the Constitution. Again, it is being reflected here. The jurisdiction conferred on the Supreme Court by Article 32 is an important and integral part of the basic structure of the Constitution, because it is meaningless to confer fundamental rights without providing an effective remedy for their enforcement if and when they are violated. A right without a remedy is a legal conundrum of a most grotesque kind. While the draft Article 25, which corresponds to Article 32, was being discussed in the Constituent Assembly, I draw your entire attention, dear friends. Now, the Honorable Supreme Court is not only referring to Article 32, but also what was discussed in the debates, Constitution Assembly debate. So, was being discussed in the Constituent Assembly, Dr. B.R. Ambedkar made a meaningful observation by saying, if I was asked to name any particular article in this Constitution as the most important, an article without which this Constitution would be a nullity, I could not refer to any other article except this one, that is Article 32. It is the very soul of the Constitution and the very heart of it. I am glad that the House has realized its importance. Our Dr. B.R. Ambedkar, before whom we are reading in the year 2024, but it was discussed long back in the Constitutional Assembly debates, still the words of the legal luminaries are existing, are true. And Article 32 is the very heart of it, and I am glad that the House has realized its importance. Where it is reported, dear friends? It is reported in Constituent Assembly debates, December 9, 1948, Volume 7, page number 953. So, taking the guidance from the Constitution Assembly debates, though the right guaranteed by Article 32 is one of the highly cherished rights conferred by the Constitution, the purpose for which that right can be enforced is stated in the very article which confers that right. The violation of a fundamental right is the sine qua non of the exercise of the rights conferred by Article 32. Just one or two more paragraphs, dear friends, very important, and it has to be recorded, that disposes of the question as regards the maintainability of the writ petition. We feel concerned to point out the maintainability of a writ petition which is correlated to the existence and violation of fundamental right is not always to be confused with the locus standi. What they are saying is, this is where this led to the public interest litigation. They were discussing what is the violation of the fundamental rights, that is separate, but who maintains a writ petition, it is different. Therefore, don't confuse with the locus standi and the violation of the fundamental rights. So they are distinguishing it. Even for somebody's violation, somebody can maintain a petition. So we feel concerned to point out that the maintainability of a writ petition, which is correlated to the existence and violation of a fundamental right, is not always to be confused with the locus to bring a proceeding under Article 32. These two matters often mingle and coalesce, with the result that it becomes difficult to consider them in watertight compartments. See, it should not be rigid. It should not be seen in a watertight compartment. The question whether a person has the locus to file a proceeding depends mostly and often on whether he possesses a legal right and that right is violated. But in an appropriate case, it may become necessary, in the changing awareness of legal rights and social obligations, to take a broader view. Dear friends, see, the locus standi interpretation was narrower before, but in this case, how beautifully expanding the scope of locus standi, which led to the birth of public interest litigation. In an appropriate case, it may become necessary, in the changing awareness of legal rights and social obligations, to take a broader view of the question of locus to initiate the proceedings. If a public property is dissipated, it would require a strong argument to convince the court that representative segments of the public, or at least a section of the public which is directly interested and affected, would have no right to complain of the infraction of public duties and obligations. Public enterprises are owned by the people, and those who run them are accountable to the people. The accountability of the public sector to the parliament is ineffective because the parliamentary control of public enterprise is diffuse and haphazard. We are not too sure if we would have refused relief to the workers if we had found that the sale was unjust, unfair, or malafide. Finally, what has happened is the Honorable Supreme Court has said that writ petition was dismissed because there was no violation of the fundamental right with respect to Article 19(1)(g) or Article 14. They can sell out their plants and equipments that would not amount to violation of the fundamental rights. But having dismissed the petition, but still the Honorable Supreme Court has held and interpreted how the broader view of locus standi is to be seen in the interest of public at large. Therefore, dear friends, we have discussed from the beginning. Generally, let me sum up, dear friends. I am summing up. The summing up of the entire debate or the entire discussion was this. Article 32 clause 1 says right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred under Part 3. Generally, the traditional view was, how do you maintain a petition? How are you aggrieved? Where is your fundamental right? Show your fundamental right, and how such fundamental right is violated. So once these two elements are established, you can establish that you are an aggrieved party, therefore you can maintain a writ petition. But this narrower interpretation with respect to locus standi was diluted for the simple reason Indians were not rich, so rich. They were not able to reach or have access to the justice at large. They were poor, underprivileged, uneducated, socially, economically backward. So they were not in a position to have access to justice. They were not in a position, financial means to engage a lawyer. But the preamble of the Constitution of India says it has to secure to all its citizens justice. Where is the justice? Injustice is going on. Prisoners are languishing in jail for many years. Therefore, which is being obstacle from rendering justice is doctrine of locus standi, an interpretation given by the Honorable Supreme Court in earlier judgments. But the Honorable Supreme Court has held it cannot be done. Narrower interpretation cannot be possible. We need to give wider interpretation and make sure that our doors are open, doors of justice are open to all. But it can be even maintained by public spirited person on behalf of poor, underprivileged, illiterate people. Though his fundamental right may not be affected at all, but he can maintain a petition on behalf of the others. So how these case laws, what we have discussed, is to show that the Honorable Supreme Court on different occasions, Hussainara Khatoon case, Fertilizer case, Mumbai Kamgar case, all these cases, they had the interpretation of saying the doctrine of locus standi has to be diluted to accommodate every one of us to reach justice. But still, we have not touched upon how the public interest litigation has deeply rooted. This is only a seed of public interest litigation shown in this case laws. In the upcoming sessions, we will be dealing with how the public interest litigation as a tree has deeply rooted in this soil, number one, and how the public interest litigation as a tree has developed its various branches with respect to wiping the tears of the people, with respect to prisoners' rights, with respect to women who is not in a position to approach, children, environmental issues, transgender issues. So everything it has got these branches. Thereafter, most important, how the misuse and abuse of public interest litigation, how it is politically motivated, how it is personally motivated, whether PIL is it public interest or paisa interest or many other interests. So whether misuse and abuse, how it has gone, and Honorable Supreme Court, how they have come out with, to maintain the sanctity of PIL, they have come out with guidelines, strict guidelines. So we are going to see in a broader way. Therefore, this will not only help for our everyday practice, and that also helps us in AOR examination. So with this, I am very happy to stand before you all to share my thoughts with respect to the PIL. Before I conclude, I have a good news for all of you, that we started Dr.P.V.SARAVANARAJA-LAW Lights on 26th November 2020. The object of starting this YouTube was to dispel the darkness of ignorance and light by sharing the knowledge. And now it has crossed more than 1,000 subscribers. It is all because of, it is not an entertainment channel, it is a pure educational purpose it was started. But where there is a goodness, the good hearted people will follow, make a comment, make a subscribe and like, and they are doing it. At this time, I will be failing in my duty if I do not acknowledge the contribution and made by Mr. Tekchand. He is my associate. He was my student at Lloyd Law College. Thereafter, he became my associate. Now he has become a part of my family. As a recognition of his immense contribution, I would like to gift this book. I welcome Mr. Tekchand to come forward. You are all the eyewitness. And this is a book, yes, Practice and Procedure, where it is meant for AOR examination. He has 3 years to go, but as a seed of AOR preparation, I am sowing it today with the hope and belief that he will come out with flying colors. And on behalf of all of you, I am gifting this. This is not a mere gift. He has earned out of his hard work, sincerity, and this is a recognition I would like to give it to him. Yes.
So I think the time has come for you to write your own book.
Thank you. Thank you.
Thank you so much.
Thank you, sir. Thank you. Yes. Yes.
Look into the camera. Thanks.
Thank you so much. All the best. All the best. All the best.